It is my honor to welcome you to this side event where we will discuss the issue of torture and refoulement in Lebanon, which are actually held on the very day Lebanon undergoes its universal periodic review. This moment is particularly significant. The UPR is intended not only as a procedural exercise, but as an opportunity for genuine scrutiny and renewed commitment to international human rights obligations. Lebanon is a state party to the UN Convention Against Torture and adopted an anti-torture law number 65 in 2017. Yet, despite these formal commitments, torture and ill treatment remain widely reported in places of detentions, as will be discussed by the panelists. I just wanted to mention that the latest victim of torture is an individual called Mohammed Harkous by security agencies, and is an example of an attempt to manipulate forensic report, the latest example of that. Oversight of security agencies remain inadequate, accountability mechanisms are weak, and survivors of torture continue to face immense barriers in accessing justice, redress, and rehabilitation. And unfortunately, these are not marginal or exceptional failures. They point to a deeper structural deficiency that allow torture to persist in practice. And at the same time, Lebanon also continues to engage in practices that violate the principle of non-refoulement, particularly in relation to Syrian refugees. Individuals are arrested, detained, and forcibly returned despite well-documented and foreseeable risks of torture, arbitrary detention, and persecution upon return. It's important to recall that non-refoulement is not merely a refugee protection principle, but actually under Article 3 of the Convention Against Torture, states are strictly prohibited from transferring any person to another state where there are substantial grounds for believing that they would be in danger of being subjected to torture. And the Committee Against Torture has been clear and consistent in its jurisprudence. Refoulement in such circumstances constitutes a violation of the prohibition of torture itself. In this sense, forcible return to a real risk of torture is not just adjacent to torture, it is recognized as an integral part of it. And beyond the refugee context, we are also witnessing a troubling pattern of transnational repression involving political dissidents. The extradition of individuals from Lebanon to other states, despite credible risks of torture and unfair trial, raises serious concerns about the erosion of legal safeguards on the misuse of regional cooperation mechanisms. These issues are actually deeply interconnected: torture and detention, refoulement, and transnational repression. I encourage, obviously, all participants in the room to engage actively in this conversation and to reflect on how concerns raised today can inform meaningful scrutiny and follow-up within the UPR process. Thank you, everyone, for your presence and your commitment. I look forward to a constructive and substantive discussion with our speakers who will touch upon all these issues in more detail. First of all, I'd like to turn to Mr. Mohammed Sablouh. He's a Lebanese lawyer and head of the legal support program at the Cedar Center for Legal Studies. He previously served as rapporteur of the Prisons Committee at the Tripoli Bar Association and director of the Prisons Rights Center. My first question to you, Mr. Sablouh, what patterns of refoulement are Lebanese authorities using against Syrian refugees, and what risks do returnees face?